Michelle Wu, the Boston mayor, by way of Barrington High School. I believe she was the valedictorian. It's remarkable how such a smart person can behave so ignorantly, say things that are so ridiculous. But that's what ideological blinders will do.
Every person, every human being has the legal right to come to the United States and seek asylum or shelter.
Well, we're going to have to create some more room at the end if 8 billion people, or 7.65 billion people, can come to America. I mean, I know what she's saying. Under the law, you have a right to petition the country for asylum, but I don't think it's going to be very persuasive, for example, if citizens of Western European countries, say, petitioned America for asylum. Although increasingly it's getting compelling given the free speech restrictions and arrests in the UK, for example. But the point is that she is not attempting to make a technical point. She is attempting to make the no person is illegal point. And this is the sentimental nonsense that you get in this discussion. It is so difficult to have dialogue on the merits because you have these demagogues in mayor's offices and governor's mansions around the country. Now, as I mentioned earlier in the show, there is some separation. There are some people on the other side that are increasingly uncomfortable about what their fellow travelers are doing and saying. One of them is Pennsylvania Senator John Fetterman, who had this to say about the histrionics over ICE officers wearing masks and so forth.
I come from this as an absolute secure border Democrat here, and that's where we're at. Like, focus on the secure our border, deport all the criminals, and that we can figure out now. And I also say now, some of the agents wearing masks, I think primarily that's driven by people are going to dox those people. That's a serious concern too. Absolutely. They could target their families, and they are organizing these people to put their names out there. So don't ever dox people and target their families too. So that's part of the churn as well now too.
Okay.
That seems pretty commonsensical and prudent. I wanted to fold one more voice in on this discussion before we get to our next guest, and that is David Sachs, who's one of the tech bros, very successful venture capitalist that is included in the All In podcast group, and he just offered basically a straightforward distillation of what's happening in Minnesota and what the real gambit here is from the open borders, abolish ICE left. First of all, on the deaths of Renee Good and Alex Preddy.
In a way, I feel sorry for Good and Preddy because they were the victims of a tinderbox that was created in Minnesota by the extreme rhetoric and decisions of Tim Walz, Jacob Fry, and the political establishment. The local police in Minneapolis should have been allowed to keep conditions safe on the street by creating a perimeter and keeping protesters away from ICE officers who were executing lawful warrants of arrest. But the police were told not to. And then the agitators stepped in and they took advantage of this sort of vacuum of authority to physically intervene. So I think it was almost inevitable that some sort of tragedy was going to result from this abdication of public safety.
Yeah, which is what Tom Homan warned about months ago. Sachs goes on to say, why are these protesters and agitators, why are they risking such deadly confrontations? One is, you've heard these arguments before, but it's good to have another voice lend credulity to it. One is to distract attention away from $9 to $19 billion in fraud that the power structure in Minnesota didn't seem particularly interested in investigating, uprooting, and frankly still doesn't, which is why the feds are doing it. And secondly, this.
They want to thwart mass deportations because illegal immigrants are a vital part of their power base. And you can see this in the 2030 apportionment forecast, which just came out. Illegal aliens count towards the census, which occurs every decade. And the census determines the apportionment of congressional seats and electoral votes. And what you see in these maps is that citizens of blue states have been migrating to red states because those blue states are failing. And as a result of that, blue states are expected to lose 9 House seats and electoral votes because of the changing population numbers. Illegal aliens in blue states have been propping up those numbers. And so, for example, in the last election, President Trump would have won an additional 9 electoral votes if we had an accurate counting. So look, this is not about principle. This is bare knuckle politics. The Democrats are playing for keeps. They don't really care how many innocent Americans get hurt or killed in the process. This is about thwarting a popular policy of deportations and sealing the border, which the American people voted for. So don't let the media fool you.
For more on this, please be joined by Ilan Wurman, the Julius E. Davis Professor of Law at the University of Minnesota and co-host of the Rationally Based podcast. Professor Wurman, thanks for joining us. Appreciate it.
Yeah, thanks for having me on your show.
Your reaction to what Sachs and Fetterman basically had to say about what is right and proper and what the angle of incidence is here for people like Walz and Fry.
So let me say 2 things. The first is everybody understands that federal law is, of course, supreme within the domain of the federal government's power, and I don't think anybody really disputes that immigration is within the federal government's power. And so this lawsuit that was filed by Minnesota, even the judge was like, which was a Biden-appointed judge, tossed it out and basically said, what are you talking about? This doesn't invade the sovereignty of the states. And in fact, made this really interesting point, which is the second thing that I want to talk about, that she said something about how, sanctuary city policies can be, the surge in federal officers can be attributed to sanctuary city policies. And that's exactly right in the sense that when you go back in history, it was actually the anti-federalists, the people who were distrustful of national government power, who wanted state officers to help enforce federal law. Why? Precisely because they distrusted federal officers whom they called a swarm of harpies, by the way, which is the title of our last episode of the Rationally Based podcast. They were afraid of the swarm of harpies of federal officers coming in from out of state to enforce federal law. State officers would be closer to the people. They're elected by the people. They would sort of mitigate the rigors of the law. And that's so the sanctuary city policies strike me as exactly backward when you think about it, right? If you impose the sanctuary city policies, then you're going to get those swarm of federal officers from out of state who have a right to come in and enforce federal law. So the whole thing seems, in my view, to backfire. So there's plenty that both sides, of course, can do to dial it down a bit. But the sanctuary city policies, are part of that equation.
Right, and I think there's a lot of frustration among people who do believe in law and order and do believe in the enforcement of immigration law. Say, well, how is it that you can have states just declare that basically their state or their big city is a federal law enforcement free zone?
Okay, well, so they, of course, can't do that. So South Carolina tried to nullify the infamous Tariff of Abominations in 1828 and the early 1830s, and Congress literally enacted the Force Act to give Andrew Jackson the right to go in and enforce federal law in South Carolina. But there is this other doctrine that you have to keep in mind. It's called the anti-commandeering doctrine, which the conservatives very much liked in the 1990s when Congress passed this law that required county officials to help enforce federal background checks on guns, gun purchases, and some conservative county sheriffs were like, we don't want to enforce federal law. And the Supreme Court agreed. Justice Scalia said that the federal government cannot commandeer, it cannot coerce, it cannot co-opt state officials into executing the law. And there's a question as to whether, if ICE calls you and say, okay, come and hold this individual in your jail so we can come and enforce federal law. Is that commandeering? Well, in one respect, it's probably not, right? Because it's like we want to enforce federal law. But if the state officials are holding them longer than they otherwise would, is that commandeering for like 5 minutes or 5 days or however long? So there's this question, but there is a difference between, it's true that the federal government can't commandeer, but the states also can't obstruct, right? And I do wonder sometimes, if a private person, knew that somebody was, wanted by the federal government for some crime and then kind of let them go, would they be like an accessory after the fact in some respects? So there is some degree of obstruction here by the states, but you always have to kind of assess that in light of this anti-commandeering doctrine. So the constitutional doctrine is actually quite complicated, but to answer your question directly, of course federal law cannot be nullified, it cannot be obstructed, it cannot be interfered with by state officers, and if that's what's happening, then that would of course be inappropriate and unconstitutional.
Right. You need it's gooey as you describe. And so it takes sort of a bright line incident like that Milwaukee judge aiding and abetting an illegal immigrant's escape from the courthouse in order to say, okay, well, that's clear interference. It's not just not collaborating. It's actually actively interfering. And that's sort of yeah.
Exactly. That's exactly right.
The issue of that David Sachs brought up, census. Counting people, counting people in this country that are here illegally, just as with birthright citizenship. The phrase "subject to the jurisdiction thereof." This is something the Supreme Court has taken up.
Yeah, so subject to the jurisdiction thereof comes in the birthright citizenship context of the 14th Amendment, Section 1. The enumeration clause or the census clause is a combination of the original Constitution and the second section of the 14th Amendment. And people say, like, oh, how can you not count, you have to count people who are here illegally. You have to count people who are here on student visas and work visas because it says you have to count the whole number of persons. But that's actually not what the clause says, at least not exactly. We don't count people who are on tourist visas in the census, which is kind of interesting, but they're persons who are here, so why aren't they counted? Well, it's because the actual clause says the following. It says representatives and direct taxes shall be apportioned among the several states according to their respective numbers, which shall be determined by adding the whole number of persons and then excluding Indians not taxed. And historically, it also said 3/5 of other persons. So the question here is, does it actually require the counting of all persons, the whole number of persons, or does it require figuring out who is among the respective numbers of the state? What does that mean? I think it means, and certainly this lawsuit in Missouri that was just filed over the census litigation, the question of a state's respective numbers is a question of who is part of the political community of the state. So you have to figure that out first. It includes citizens, historically included permanent, aliens who are there in permanent residence, inhabitants, but are people who are there contrary to the laws or people who are there temporarily part of the numbers of the state. So if I could draw an analogy, it's like if the clause had said, you shall apportion representatives among the states according to their respective French population, counting the whole number of persons. You wouldn't count every single person. You would count every single person who's also French, right? And so the question is, who are among the numbers of a state? And do you count people who are there illegally or transiently? And so it's a very interesting constitutional question, and I think the Missouri litigation over this has some real legs to it, and would have, as you said, dramatic apportionment consequences.
And we've discussed birthright citizenship quite a bit on this program, including with UFC professor Richard Epstein, who argues that that it is not constitutional, that the interpretation that's being used, subject to the jurisdiction thereof, to uphold birthright citizenship is erroneous. What is your distillation of that matter?
Yeah, I've been getting a lot of heat for this. Actually, Professor Epstein and I are the only two law professors who wrote briefs in support of the administration's view on this. I do think it's quite more complicated. The traditional view is that anybody born in the United States or at common law in England was a subject of the king's, but then, what do you do with the exception for ambassadors, the children born of ambassadors and the children born of foreign soldiers? Like, why don't they count for birthright citizenship? And the answer, when it was precisely stated, was that those children, although born in the king's realm, in the king's land, were not born under the king's protection, and more specifically, even more precisely, they weren't born to parents under the king's protection. Ambassadors were within the allegiance and the protection of a foreign sovereign. Foreign soldiers were under the allegiance and protection of a foreign government that was sending them. And what I have tried to show in my work, that when you go back in the history to come under the protection of the king as a foreigner required really one of two things: either a safe conduct, which is like this royal passport from the king that granted permission to come in and granted the person protection, or the statutes gave permission. Magna Carta gave permission and protection to friendly aliens to come into the realm of England unless they had been previously and publicly forbidden. The statutes of Edward III said that merchant strangers may safely and surely and under our protection come and dwell in our said realm. And so what I try to show is there's actually no evidence to suggest that if an alien had come contrary, without a safe conduct, and contrary to the laws of the realm, would that alien parent have been under the sovereign's protection for purposes of the birthright citizenship rule, right, such that their child would be a natural-born subject? And I think the answer is very complicated and probably not. And so everybody has been assuming that mere birth alone is what created this rule, but actually it was this concept of protection. And so at least to the extent that the Supreme Court cares about the common law history, which it may not, right? It may not. I mean, the federal government's brief really focused on the legislative history and how interpreters of the 14th Amendment interpreted it in the first few decades after. There isn't very much on unlawfully present aliens in that discussion, those discussions, but there's a lot about how temporary visitors were thought to be excluded. So there's a lot going on here. It's a very complicated issue. And so anybody who tells you, oh, this has been settled and it's a longstanding rule and it's open and shut, how dare anybody question the conventional wisdom? Well, you should never trust people who talk like that.
Yeah, that's a good rule of thumb. So it would require some official designation. So you're here legally under a grant of asylum, for example. Then you say, okay, well, there's a legal designation, a formal issuance that you are protected in a way that somebody who is just here illegally, no matter how long, is not. And perhaps the Supreme Court would draw those sorts of distinctions?
Right. At common law, anyway, that was the relevant question. And also in the United States, there were cases like, in the War of 1812, we were at war with England, with Great Britain, and there were British subjects in America who were not part of any foreign force. Okay, but they were just living in America. And the question is, were they under the protection of the United States if their nation was at war with us? And so there was a case in New York. A very famous chancellor, James Kent, decided the case and explained that he said as follows. He said, a lawful residence implies protection and a capacity to sue and be sued. So as long as this English subject, even though his country was at war, was lawfully here and wasn't prescribed, wasn't told to leave, like under the Alien Enemies Act or by statute, right, he was under the protection of the United States. And as a result of that protection, was also subject to its jurisdiction. That's what gave him a capacity to sue and be sued in the courts and enforce our contracts. And so that also, will the Supreme Court look at all this? I have no idea, but it might. And so I just wanted to write, my brief to suggest that if you do look at the common law, it's actually quite more complicated, whether you agree with me or not. And I'm getting a lot of, vicious attacks on, from academic colleagues, which is to be expected. That's par for the course. But at a minimum, it is a far more nuanced and complicated issue than has been traditionally believed.
He is Professor Ilan Wurman, Julius E. Davis Professor of Law at the University of Minnesota, co-host of the Rationally Based podcast. Professor Wurman, thanks so much for joining us. Appreciate it.
Thank you. Have a great day.
You too. And you join us on Chicago's Morning Answer.
Hear about the big stories of the day, then talk about them right here on Chicago's Morning Answer on AM 560. The Answer.
If you or someone you love are getting high quotes for dental implants, visit almostfreeteeth.com today. With a medical PPO insurance plan, it's possible to save 90% off on average to be able to smile again. Check if you qualify now at almostfreeteeth.com.
AM 560, The Answer.